we're going to be talking about smart strategies to address and overcome the global regulatory challenges that all of our security and privacy pros face. So we've got a fantastic panel of experts. We've got a CISO. I'm going to ask everyone to introduce themselves properly in a minute. We've got a CISO, Richard. We've got a regulator, Jonathan. We have an attorney, Bridget, and we have a data protection officer, Steve. So guys, if you can just give me a minute about what you do and what your job roles are, please.
My name is Richard Starnes. I'm the CISO for the Kentucky Health Cooperative. You may have all heard about Obamacare, and we're one of the insurance companies that was created as a result of that legislation. We have the same regulatory footprint as a standard insurance company with a couple of extra things tacked on. I'm also a part-time investigator for the Franklin County Sheriff's Office, which is where I was before I became a CISO.
Okay, I'm Jonathan Bamford. I'm the Head of Strategic Liaison at the Information Commissioner's Office. We're the UK regulator for data protection laws, and my job in the ICO is to make sure that we make a difference, that we influence key stakeholders in how they're developing things, influence public policy, respond to all the sorts of developments that are going on that we need to have a view on and policies about. And I've worked for the ICO since our first generation of data protection laws was first established back in 1985, the 1984 Data Protection Act, so I'm 30 years old in data protection years.
Well, I'm not as old as Jonathan, but in data protection terms at least. I'm Bridget Tracy. I'm a partner at Hunton & Williams, a US law firm with an office here in London, and my practice focuses solely on data protection and cybersecurity issues. And it's my job really to keep our clients away from Jonathan and his colleagues. My clients are primarily quite international companies wanting to do some new and innovative things with the data around the globe and trying to navigate the right way through the data protection laws. Steve.
Hi, everybody. My name's Steve Wright. I'm the Chief Privacy Officer for Unilever. As you may or may not know, Unilever make Magnum's ice creams or Marmite, and you love it or hate it, but essentially it's a fundamental part of almost 2 billion consumers per day touch our products around the world. And we're in 190 countries. We have 170,000 staff. And my job is to advise and steer our board and our marketeers on what to do around data protection globally.
Fantastic, guys. So look, we've got this mass of new regulations coming through. Europe, it's churning through a data protection regulation, new cybersecurity directive. We had a payment services directive not long ago, and a new e-trust directive. So a lot going on in Europe. In America, President Obama, he wants a new privacy law, a new cybersecurity law. So how do we cope with this complex environment? So that's what we're trying to get to, is how can we be smart in a strategic sense to cope with our compliance obligations? So the first question, Steve, just a thought to you is, look, there are just too many laws out there. So as a company, you've just got to be illegal at times and deal with the major points. Is that right? Or are you going for total legality? Steve?
Well, of course, the answer is we're going for total legality. What I will say, though, is that much of the legislation around the world is down to a level of risk-based analysis. So it's not a case of one size fits all around the world. Yes, you can have a baseline standard that's applicable to pretty much the 120 countries that have data protection laws and regulations. That's not to mention all the other regulations that are in place. There is a case, though, that each country will have a certain level of interpretation and tolerance to those laws and those regulations, and it's about understanding those local nuances, understanding those cultural differences, and making sure that you're working hand in glove with your legal counsel on a local basis to adapt and ensure that you've got compliance locally.
Right, Steve, I know you're in a difficult position that you could not possibly own up to not obeying some of the laws. So, Bridget, I can ask you, because you act for people who probably don't obey all the laws, and you can keep a lid on it.
And I've got the regulators sitting next to you.
And you've got the regulators sitting next to you.
Thank you very much.
So I'm making notes.
But, Bridget, as
Yes.
a lawyer, we know that when the clients come through the door, that they're going to have to make a big call about priorities. I mean, what are you seeing in your practice about this issue? Do we have big issues that we want to deal with and forget all the rest, or are people going for a much more blended approach?
I think the risk of a blended approach is that you don't necessarily get it right anywhere. But certainly, if you try to comply with every single law in every single jurisdiction that has some kind of data protection law, I think your business would be tangled up in knots. I think really what we see organizations doing is starting from the sort of ground point that they want to be compliant, and then they want to develop a program that gives them an opportunity to ensure the greatest level of compliance across the jurisdictions in which they do business. So that really is their objective. But when it comes to prioritizing compliance around the globe, they will look to jurisdictions that have the toughest laws, and they will look to the jurisdictions that are the most significant for their business operations. And so that combination of the most conservative jurisdiction and the most important jurisdiction for their business will help them to prioritize their compliance initiative. But I would say that if you look around the globe, and this is changing actually, but I think we see more convergence. We see more similarity than difference. I mean, sure, there are still some differences, and often in areas that touch data protection law, but are not the core data protection laws. For example, employment laws are very different around the globe and can have a significant impact on how an organization structures its compliance program for processing HR data. But the organizations will still try very much to have a program that operates on a global basis, taking advantage of the commonality, and then to the extent that there is difference, they will pick that up on a jurisdiction by jurisdiction basis where that's required.
I'm going to play Jonathan in a second, but Richard, you can tell the truth because he's not your regulator. So as far as your entity is concerned, where are you going in the US on your compliance obligations? Are you prioritizing things, or are you trying to get everything done?
What we do is we look for commonalities across the regulatory frameworks and work on getting those commonalities in place, and then we start going backfilling on the things that are not common across the different regulatory frameworks. That will get you the greatest impact quickly. I'm going to say that I don't consider regulators to be the enemy, and I think a lot of people approach it that way. I think regulators and auditors are there to be partners with the companies and help us to reach a better security framework, a better security product for the company as well. And they shouldn't be treated that way.
Jonathan, can you challenge that? Are you the enemy or not?
We don't like to think of ourselves as the enemy, because every time we take enforcement action, every time we issue a monetary penalty, that's a sort of failure in some way, because an organisation has had a data problem there, and we haven't been able to make sure that they don't have that problem by providing advice, guidance, incentives, those sorts of things. What I can never say to anybody is it's okay to break the law. It's like trying to ask police officers, okay then, if I speed just above 30 miles an hour, what's the magic number where I get a ticket and where I don't get a ticket? Anybody who enforces laws will never say it's okay to break a law. But what we do is take into account the efforts that people really make to try and assess whether they've got risks, to address those risks, and importantly, to learn from previous mistakes. The thing that really annoys us and where we get really upset is where people have had problems before and they've not learned from them. And that's an important thing there. Learn from your mistakes, learn from your near misses. And hopefully as a regulator, if you come to us for advice when you've had those sorts of things, we won't be reaching for our pads of notepaper with enforcement notices on. We'll be trying to help make sure it never happens again.
So Jonathan, you can just carry on with this a little bit more if I can. So you've got a tolerance then for failure because mistakes happen. But if the business or the entity is showing the right attitude, has got the right mindsets, that's not going to be the entity that's going to get into real trouble with the regulators. The people who are being dumb, being stupid, and just making deliberate decisions not to address risk. Is that broadly right?
There's an element of that that's right, but you're putting far too many words in my mouth there for my liking. We do take that into account, but there can be occasions where something is so severe that's occurred that we need to take action, even though somebody did do something which was generally the right thing to do. There is something that's happened there that requires a regulatory response, and we are going to take action in those cases. But in terms of that scale of what we do, and an obvious example is the level of a monetary penalty that we might impose, we will take into account the circumstances, what people have done to try and address this problem in the past, or importantly, not address this problem in the past, and that can aggravate things.
So we can have then, Jonathan, I'm going to just this last bit then play in the guys again. So we can be pretty good at data protection, regulation, security, compliance, and all that stuff, but there are some failures that are just so bad that you're going to get into real trouble with a regulator, regardless of the general good behaviours you display. I
think that's right. I always feel sorry for organisations that do a lot to train the staff to do the right thing, and then they do something which is completely wrong-headed and make a massive mistake against everything that they've been told. But if that causes some real damage and distress to lots and lots of people, as a regulator you can't just turn Nelson's eye to that. What happens is there's an element of mitigation there by the efforts that the organisation's made in the past. We can't just say it's swept under the carpet, it never happened. We have to deal with it properly. The people who have been affected expect us to deal with it properly, and we have to do something about it. What we do is informed by the general circumstance.
So what I'd like to do now is just play in the guys, just two different views. I want to get the legal view, then the business view. So we've got a priority issue going on here, Steve. For you as an entity, for Unilever, what do you see as the big priorities that you want to address in a smart way?
Well, for us, it's playing a lot on what Richard said, and really carrying on from my colleagues here, just generally across the panel. This is about trying to comply, but also doing risk-based. Where are the heat spots? Where are the points of entry to market that you're particularly growing, where it's relatively new, or where the regulator is also relatively new? There's also about the quantity of data, because let's face it, if you're talking about vast sums of data, then obviously the risk of a potential breach goes up. Whereas if we're dealing with very small amounts of data and it's quite discrete pieces of activity in a particular market or sector, then you can control that much better. So it's just about understanding that risk around the world where you're doing business, and then putting in the right amount of control. And the one thing that is really pertinent, and certainly has worked for us at Unilever, we introduced a standard baseline, what we kind of call the watermark. And that was really the minimal best practice that we felt was right. We looked at 120 different laws around the world, and we derived that there were principally about 36 principles or controls that needed to be applied wherever you're operating a business around the world. And for us, that became our de facto standard. Now, what happens, though, is the trading environment in that particular market may be up or down, and therefore that has to be applied, respectively of the level of trade, essentially. If there's more market, if there's more digital or social media activity in those markets, certainly in D&E markets where we're heavily trading at the moment, then you need to respond accordingly, and you need to take that watermark higher in those markets. So
Steve, are you comfortable sharing with us any specifics about what are hot topics or big issues for Unilever? I mean, for instance, is it customer consent, or is it the security thing? You know, where are you seeing the big issues globally?
Well, it's not so much. So certainly in Europe, where I would say that we've got there's culturally a higher level of understanding and acceptance to explaining why we have to do X, Y, and Z in order to comply with this. When we go elsewhere in the market, certainly down in Southeast Asia or in LATAM, then that's it's naturally meted. This is new to them, so you're taking these people on a journey. And it's not a case of just saying, here's the draconian law, you must comply with this or else. It's about understanding and helping them go on that journey to get them to that point. Now, I think to answer your question specifically, Unilever has always operated in a very ethical way, right from its outset. You know, if you look at its history, it's been very ethical. So it's always been about making sure that we respect the rights and have the appropriate consent. However, it doesn't mean that a regulator such as my colleague here, if he went and did a test in a market in Indonesia, it may be a very different test to what we have in our German market, and therefore it would have to be appropriate to the level of risk and the level of understanding and cultural acceptance in that market is very different. What we've got to remember at the end of the day is we're here to do business. You know, Unilever have a duty to its shareholders and to its consumers and customers, and they want those products at the best possible value at the lowest cost. So what we've always got to keep in the back of our minds is how can we achieve this and balance that risk with that level of exposure whilst respecting the rights of individuals. And that's my job, to regulate that.
Richard, same question to you. So in healthcare, I mean, what's the big priorities that you're dealing with? I mean, is it security? Is it accuracy? Is it something else?
Well, security is obviously the area that's of great concern to me. Our own internal infrastructure is not that bad to deal with.
Yeah.
All of our IT folks are cross-trained in security, and they all have security components of their jobs, so they're held accountable to the infrastructure for that. The biggest problem that I have is I have 42 vendors that hold some of our data or all of our data. And the vendors are my nightmares. I've got vendors that don't have CISOs. I had a vendor that sent me a scan of their network. I requested a quarterly scan of their network. They sent me a scan of the network. Turns out it was a 1,000-page document. They hadn't sent me a scan of my portion of their network. They'd sent me a penetration scan of the entire network for all of their customers. This kicked off another problem. And then I said, so what's your mitigation strategy for dealing with these vulnerabilities that came up in the scans? And they said, we'll get that right to you right after we write one. So these vendors are taking in regulated data, and they're not holding to their BAAs, their contracts that they're required to under HIPAA. And so we have to watch these folks very closely and, in a sense, become their CISOs until they're capable of handling the data that we need them to handle in the proper manner.
So Steve wants to come back in before Bridget.
I think, you know, a lot of this comes down to, and I know Richard and I worked together many years ago, this comes down to the good old wet issue of people, right? And essentially we're facing the same dilemmas, the same challenges that we faced as a security industry many years ago, and that's about accountability and ownership. So what we've got here is a problem where people don't understand the obligations. They don't understand necessarily, not in a malicious way, but in a naive way, what they're doing with the data, where the data is being taken from and to, and what they should be doing as a minimum checklist to ensure that that data is adequately protected, or the rights of those individuals are adequately protected. And that's principally what it comes down to: accountability and ownership.
So Bridget, let's get the lawyer's view. Can I pray, Bridget, I want to come back, because I want to ask you about how clever or smart the strategy is about you becoming everyone's CISO. So if you can have a little think about that for me for a second, Richard. So Bridget, I mean, what about you? Advising the world, lots of priorities. I mean, what are the big issues that you're seeing being prioritized in your client base? So there's ideas that we'd like to get. We're going to build smart strategies. You know, let's ask the lawyers what they're seeing, because we can aggregate all the knowledge, just like the regulators. So what are we seeing?
Okay, so I think there's a range of issues actually, depending on where you're doing business and what kind of business you have. For a lot of companies, actually, they're not in the B2C space at all, and probably their riskiest data bucket is their HR data. So a strategy for that company is going to be very different to a company that is primarily processing consumer data. So I think that's the first thing, is the strategy and the prioritization will differ depending on what kind of data you're processing. And then, of course, if the data that you're processing is really sensitive data, like health data, then, again, you have got a different focus to the companies not processing health data. In terms of issues, and actually, before I go on to issues, the other thing I just wanted to say, when we look at global compliance, I think it's also worth noting that quite a lot of data protection law is not black and white. Some of it is, but in other respects, it's not. And there's a great deal of grey. And that's particularly the case in a European context, where our law is principles-based. Now, that's going to tighten up with the proposed general data protection regulation currently being negotiated. But there will still be areas of grey, areas where organizations are expected to analyze risk and to make appropriate decisions. We're not talking about not complying with the law. We're talking about what else companies need to do, and they will be expected to stand ready to demonstrate the rationale for decisions that they have taken in order to safeguard data or to make decisions about particular types of processing that they want to engage in. So there is a great deal of grey, and with grey, there is actually an opportunity then to create. And so there's an opportunity for organizations to create their own framework, if you like, that sort of fits within that grey space and will help to get them to the right level of compliance over and above the bare minimum that is required by law. And for some companies, they're going to want to have a very high level of compliance overall, and for others, that level might actually be not much more than just over sort of the bare sort of legal minimum. So I think that's just a preliminary comment to make. And then sort of standing back and sort of thinking across my client base and the kinds of issues that a lot of these companies are focusing on. For some, the issues are actually quite sort of basic, really. I think everyone is concerned about security risk. Some are more or less sophisticated in dealing with this. We ran a little survey a month or so ago amongst some clients that we were entertaining for dinner, 100 GCs, and we asked them a series of questions about cybersecurity risk. And what really struck me was that 70% of those polled said that they had not had a security incident in the previous 12 months. I was astounded, I'm sure you are too. And so I think one of the issues for organizations is that they don't have the right systems in place to identify these risk issues. And it's not just in a security context. I mean, I think the same remark can be made in other contexts as well. But security certainly is one area that organizations are understandably very focused on. And I think because of the US experience, and some of those US breaches actually affect clients around the globe, businesses around the globe. They're not just sort of limited to the US, but with data moving across borders, of course, it's going to have an impact in other jurisdictions as well. I think organizations aligned to that, we see a lot of companies wanting to roll out global systems that will help them manage some of that security risk. And data loss prevention tools are a great example of that. Now, they're also a really good example of a tool that requires very careful calibration from one jurisdiction to another. you can't just roll out your US solution around the globe, because you will run afoul of data protection laws in Europe if you do that. So that sort of is a good example of a tool where you can't just take one approach from one jurisdiction and expect it to be fine around the globe. Other issues that we see clients increasingly having to focus on relate to the development and sometimes actually just evolution of technologies. So sometimes entirely new products or new ways of processing their data, sometimes refinement of an existing way of processing data. And if these aren't properly thought through and assessed from a privacy perspective, they can give rise to some quite serious issues, including breaches, actually, of the data protection legislation. And we see increasingly this is a theme that clients come to us with this issue. People haven't really thought about how small changes to existing technologies, or indeed the rolling out of a new product, might impact data protection rights of individuals, and they just get it wrong. So we're working with clients on the ways in which they conduct their privacy impact assessments. We're talking with clients about their data protection by design focus. And for many it is very standard, but often it's standard for new products and not for tweaks and refinements to existing technologies. So I'd put that into a second bucket. I'm going to keep going. Is that okay? My third bucket?
One more minute.
One more minute. Okay.
But you have to do a dance at the end of it.
Big data. I just have to get this on it. Big data. So vast aggregations of information that can be processed very quickly and can deliver some really extraordinary insights into consumer behavior, into how people live their lives, into their health. And big data processing, I think it gives rise to some really very serious issues, particularly actually in the mobile health context. And we've done some work on that recently.
Fantastic. So, Richard, can I play you in before I bring you in, Steve? So, Richard, you had a burning point. Can you still remember it?
Oh, yes.
Please.
I was in a room, not with this particular position, but a previous consultancy, where we had dozens of attorneys in the room, British and American, and the American company was wanting to bring some data to the UK and do some manipulations. And the attorneys basically said, what you want to do, you really can't do legally. And the American in the room said, right, we'll take the data out and manipulate it the way we'll want to, and then we'll ship it back to the UK. And it was astounding to me that they didn't understand that you just simply can't do that. And most of the American side has a failure to understand a lot of the EU privacy regulations. They don't understand them, they don't understand how they work, and they should if they're going to do business in Europe.
So that's an interesting point about the extent to which we understand and appreciate obligations from other territories. And I'm going to bring that back in a second. But Jonathan, can you just wrap up on this question before we go a bit deeper? What do you think are the big priorities? So the Information Commissioner has a work plan. Every few months or so, there's a press release about stuff. So, for instance, a big app sweep has been going on. A few months ago, it was a big cookie sweep. So what are the regulators seeing as the big priorities over the next 6 months, 12 months? Because if we're going to get smart, we ought to be looking at what you're doing.
I mean, we're responding to a lot of public concerns at the moment. So we've seen that by actually lowering the base of being able to impose penalties where there's been, marketing calls or things like that, particularly the unsolicited texts and things where we can take action. So we're actually seeing us responding to where there's lots of public concern, because public are getting fed up with getting text messages and other things like that. That goes to the politicians who get fed up of hearing about this, and they start changing the laws and allow us to do things to stop this. So we're seeing that legal environment change. In the terms of the strategic one for us, we are concerned about the way that technology changes. As Bridget mentioned about big data, we've done a big piece of work on big data to try and work out what are the data protection issues from this. Can the two environments live side by side? And published a report on that one. We are concerned generally about the whole thrust of enforcement and making sure that we're taking purposeful action, not just action where it's notches on our enforcement belt. You know, we want to make a difference out there, and it's making a difference in key areas. And areas like health are priority areas for us because that's an area where the public get concerned. So we have things like information rights strategies, which actually provide the bedrock on which we build forward all our corporate activities.
Fantastic. Now, I want to just go into a theme that we were developing before. I think it was coming out with you, Steve, which is the idea that some territories are going to be more important. And you talked about the toughness of law. So just quickly, so I don't want a big narrative, but what are the big problem countries that you're dealing with? And it's the same question to all of you. You may not be dealing with them, you may not, but which territories have we got to be thinking hard about? So Russia and data localization is really a hot topic at the moment. So there's an idea that national change can change the way a business is operating on the ground.
Yeah, well, data localization is a different subject, related, albeit, and you're quite right. We set up a task group last summer to deal with data localization, specifically addressing the Russian localization issue. So we're well ahead of that curve. But of course, China and Brazil are equally making all the right noises in all the wrong places around that one. So we're having to respond to that. I think for us, some of the big issues that we're facing from a global perspective is obviously the onset of the cloud-based solutions that principally come out of US-based organizations, and the issues with safe harbor therefore become a challenge for us as well. Whether that's adequate and other adequate or non-adequate countries, whether they've got appropriate provisions in place to ensure or to give us the assurance, I should say, that we have satisfactory mechanisms in which we can litigate or mitigate some of those challenges. And I think also that just the sheer nature of cross-border transfer, be it whether that's cloud or be it whether that's our service providers, and with the onset of the GDPR, clearly that's going to have a massive change on the obligations of processors, as principally, it's been just controllers, and certainly the responsibility has been with the controllers, but now that legal obligation is now down to the processes. So we need to work with our partners, the HP, the Accentures of this world, to make sure that whatever solutions they're putting in place will fulfill those obligations on both sides. So that's a massive emphasis. So with that in mind, then we have to prioritize, right? Because we are a large organization, and really the key areas for us are certainly in LATAM, in Brazil, in Colombia, and it's very similar for the Colombian Data Protection Authority as part of similar to the FTC, it's part of the same organization, and other parts of the whole South American area or continent. And then in Southeast Asia, I'm out to Singapore on Sunday.
You're doing a whole globe. I need to leave some for the others. So let me just.
Sorry.
There's going to be none left.
Okay.
So Bridget, so we've heard there's a lot of change in developing nations, Brazil, LATAM, and any other countries where we're seeing a lot of action that we want to build into our strategy.
So can I touch on Asia then, Stuart?
You can touch on it.
So amongst the Asian countries, the countries that are quite conservative are South Korea and Malaysia in particular. But we also see China developing data protection law, and sometimes it's not quite what we expect. And we see the Singaporean and the Hong Kong regulators taking a fresh look at how they're enforcing their existing data protection laws, and in Hong Kong, seeking to refine that, so seeking to bring into force their restrictions on cross-border data transfer. And then can I also just mention the US as well?
I was going to ask Richard to tell us about the US in a second, but you can come back if he doesn't.
Okay.
Jonathan, so the Information Commissioner is part of the Article 29 Working Party, which is the group of European regulators. So which are the crazy countries in Europe that we need to be watching out for or building into our strategies? Is there anyone who's particularly tough or taking a lead?
I don't think I'd go as far as to say that any of my European colleagues amount to a crazy country.
That's why
in
I
Europe.
said it. So
What I might say is that different regulators have different regulatory models.
that's the point.
That's it.
Yeah.
So, our regulatory model is to provide incentives to people, provide them with guidance, try and get them to comply, do all we can to provide you with the guidance you need. But if that doesn't work, then we will take action, particularly if people have got their fingers in their ears and whistling a happy tune and not paying attention. In other countries, they work on different regulatory models. They don't provide so much advice and guidance. They say you can go to the marketplace for that, and we'll spend our activities and resources on auditing and trying to find out whether organisations are compliant or not. The Spanish Data Protection Authority, for the sake of argument, that has a very well-developed audit regime there, and its funding comes from the fines that it imposes when it finds breaches, often as it come about as an audit issue. We don't impose monetary penalties when we learn about things through our audit activities.
Yeah.
We don't have the power to do that as such. So there are different regulatory models there. The only thing I would say on this global debate, I suppose it's sort of appropriate that you mention it, because this week in Ottawa is the meeting of the Global Privacy Enforcement Network, which our commissioners at. You knew that. You knew that. Which the Information Commissioner's at with our head of enforcement, and we've been leading lights in this along with the Canadians and others, because we recognise that a lot of the problems we have in trying to enforce things can't be done within our own national jurisdictions and boundaries. So we have to follow the data, we have to use other regulatory mechanisms, other regulators, and as Steve mentioned, you can have different ones in different countries and different approaches. The Federal Trade Commission in the States are a big player, and they're part of GPEN. So, there's some powerful people as part of that framework, not traditional data protection regulators, all of them.
So if we just carrying on with that a second, then I'm going to ask you about which are the tough states, if you could name a few of those to me, Richard. But the regulators are sharing information now about entities. They form their own clubs. They've signed memoranda of understanding and contracts. There's a Commonwealth one, there's a GPEN, there's an Internet one. So is the picture we're getting here, Jonathan, that the regulators can cascade globally very quickly information about risk, peril, and potentially bad actors? So in a strategic sense, being aware that there can be a domino effect quickly around the globe. Is that at the heart of the regulatory system now?
Absolutely right. When you have to use the example of a security breach, when you have a security breach which is on a platform which trades globally, then there's a lot of regulatory interests engaged straight away. Yeah. And it may well be that, if we mention about the cloud, it might be in an American jurisdiction, it might be in an Irish jurisdiction. Then we need to find out quickly who's taking charge of this, who's using their investigative or audit powers to get to the bottom of it. We can't all run around like chickens with their heads cut off trying to deal with this. We need to have some structure and discipline.
So what do? Do you phone each other up? Have you got a bat phone or something like that? How does it actually work?
Well, you mentioned about old technology. No, we don't have a bat phone. We have a communications mechanism. So we've got a website.
So, thanks, Jonathan. So Richard, what about in the US? Because at state level, massive variation between priority and power. I mean, are there any really complex or troublesome or tougher states that we need to be aware about?
No, not really. They're all becoming a bit of a challenge.
I don't think you're going to say that.
You can take it as read. You have federal regulation that you have to deal with, and then you have various states. 42 of the 50 states currently have some sort of breach notification, as an example.
Yeah.
And they're all from very, very simplistic to extremely complex with a lot of regulatory compliance to it. And the problem with the way law works generally, and this is a very simplistic view of it, in the U.S., the states can take a federal statute and make it more restrictive, but they can't make it less restrictive. So if their statute is not less restrictive than the federal statute, their statute applies. So you have to take a look at where your data is located and how it's going to apply to each one of the state statutes as well as the federal statutes, which can be a bit tricky, particularly when you have the same problem that you have here in Europe with geolocation issues. Where does the data actually physically reside? And how is that jurisdiction going to be apportioned across, let's say, a large database that's in 3 or 4 different states or countries for even that matter?
So I want to change the theme of this conversation. So we've spent for many, many years looking at security and privacy as a regulator issue. So let's be worried about the feds, and let's be worried about the information commissioner, and let's be worried about the statutory regulators and the public authorities who've been given powers to oversee us. But we've got a new regulatory body coming into force, Joe Public, the citizen. And if we look at what's been going on over the past 18 months, most of the landmark changes have not been caused by the information commissioners or the FTCs, but by Joe Schmo, who uses litigation powers to drive massive change. So we have the Google right to be forgotten case with a Spanish guy causing a change in European web search. We've got this litigation against Facebook, an Austrian guy who might cause a change on transfers of data between the EU and the US. We had some pressure groups who brought down the UK scheme for surveillance, which is now being repatched up, and the telco scheme as well. So time and time again over the past 18 months or so, the citizen has been blowing us all away. Now, in a strategic sense, what are we doing to think about that risk, which is new and potentially has not been properly quantified by most of our entities? Now, what I'm talking about, Steve, is consumers. And you were giving the Marmite example. Now, the thing with consumers is they can love you or they hate you, but if they get a bee in their bonnet, they can really have you. So what are we doing on that in a strategic sense, Steve? Where are we going? And it may not necessarily be your country, but you're a big name in the circuit. What are you hearing from big corporates about consumer risk?
Well, I think it's very timely. I think you're absolutely right that what we're going to see now, in my humble opinion, is the Internet of Me, which is the whole power shifting from us as organisations trying to engage and have a two-way dialogue with our consumers, to the power being, or the emphasis being, on the individual, and they then control who and how and what and where is connected with them. And I think, to be honest, I look at this from two angles. I certainly look at it from myself and from my children's perspective. They're very internet savvy. It's very normal, and you could argue that they're very much Y generation, that they don't really care. There's a certain level of apathy involved. But also with that comes a level of responsibility as you grow up, just like in any kind of situation where that level of understanding or that maturity will gradually increase, and the issues that you've highlighted will become more, well, hang on a minute, that's a right, and therefore I don't want to share my information with those organisations. So the emphasis then becomes on the consumer, or the products and services, not just us as a consumer with 2 billion customers per day. This is about us understanding and giving the power back to the individual to control what access and what data we hold about them as an individual.
So you put them back and control their data, Steve. But what about complaints?
Yeah.
Because if you don't deal with complaints properly,
absolutely,
that's when it all goes absolutely wrong.
That's right. But let's, this isn't an overnight horror story, okay?
No,
this,
not at all.
We're not talking Twilight Zone. This is a gradual process. And there's an aspect of we're helping empower the consumer, and the consumer, by turn, is helping drive our marketeers into making the right decisions about how they engage with them. So again, going back to my earlier point about this is a two-way street, it's not just about educating our employees, who are 170,000 staff. This is about educating our consumers as well, and giving them the opportunity to take control of it. Now, I could be wrong, and we may go down the path where, no, actually, people just want to hand off responsibility, and there will always be that aspect of it. But unfortunately, we've seen time and time again, state, government, NGOs, whatever the player is, the actor in this, absolutely catastrophically fail in handling those rudimentary basic elements of respecting my rights as an individual. So therefore I want to take power back. Yeah. And let's be honest about this. This is driven by simplicity, because that's what drives it, right? Because there's always a two-way thing. When we're having a relationship with an organization, it's always about, what are you going to give me in return and what I'm going to give you, right? So you show me yours, I'll give you mine, right? So it's always this two-way dialogue. And that will drive a lot of this. And I think it's down to organizations, such as Unilever, such as many other organizations, to actually take the lead in this space and say, well, you tell us. We're prepared to do this or we're prepared to do that. And that's why I'm saying I can see it going that way. That's what I predict. And I think
there's a chance to stop it
with
the right strategic posture.
Yeah, and I think it is about sort of taking grasping.
So I want to play in Rich in a second, but Bridget, you wanted to tell me something about America, and I stopped you because I want to go to Richard being American. But now I do want to ask you about America. So with this theme about, we're talking about regulatory oversight, and I'm suggesting that if we had one regulator in the UK 15 months ago, the Information Commission, we've now got 70 million, right? So in the US, this idea of the citizen regulator, your law firm's got a massive US presence. You must be seeing the class action stuff every week in your firm's in-tray. Is that what's going on in the US, or am I overcooking it?
That is what's going on in the US, but it's not limited to data protection, obviously. No. I mean, it's across all of the issues and every area of legislation. And the consumer is king in the US. Now, I think one of the interesting things we see in Europe is that we don't have class action litigation as such. And I think culturally, we don't litigate in the same way as the Americans do either.
Not enough litigation.
Not enough litigation.
Says lawyer.
But what we will see in the proposed European data protection regulation, which I think is very interesting, is something that gets quite close to class action litigation. So there is this proposal for consumers to band together, effectively, to bring claims against organizations that haven't processed their data in conformity with the data protection legislation. It will be interesting to see whether that changes the landscape or not. That, combined with mandatory breach notification, could have a significant impact. In addition to that, I would say, though, that one of the things that is a real focus in Europe at the moment is strengthening individuals' rights and making sure that individuals know what their rights are in relation to their data. And I think the cases that you mentioned earlier, many of them are examples of individuals actually challenging organizations that may not have done the right thing with their data. And I think that as a consequence of that, I'm certainly seeing companies wanting to be much more transparent with their collection of data and with their use of data, wanting to make sure that their consumers know what is going to happen with their information, and giving them the opportunity to say, no, actually I don't want you to do that, and opting out. Now, to implement something like that is a very significant project, but we are seeing companies starting to move along those lines, who haven't previously taken that approach. And I think, and I've just got one more point to make, Stuart, on this, what I think is very interesting is that in Europe, and I guess actually learning from the US to some extent, in the US they have the FTC, who really has become the de facto data protection regulator. So they have very much a consumer focus, and they are regulating behavior by businesses which has misled or deceived consumers. So statements in their privacy notices that they can't live up to, companies can't live up to, or that they just infringe, breach, break. In Europe, our data protection regulators regulate data protection compliance, but increasingly, and some of these cases Stuart referred to, are examples of consumers bringing consumer actions. So not just relying on data protection legislation, but actually looking to unfair consumer laws. And they can bring some of those cases. Germany is a good example of this, where some of the cases are being brought through the courts, and the courts can award compensation, and they can award quite tough financial penalties.
So we're getting into the last 10 minutes. Richard, I want to ask you your views on this. So what's happening in that litigation market, if you like, in the US? So this extra regulatory oversight, how are we coping with it?
Well, I want to step back about 100 years.
That's too long. We've only got 10 minutes.
Consumers in the US and consumers in Europe have, because of the development of the different histories, different attitudes towards privacy. And I see the US attitudes toward privacy starting to migrate or move towards a more European understanding of what privacy is. Americans have always not really had an understanding of the ownership of the data that's about them, or felt a need to have that ownership. But I believe all of these breaches that we've been having are starting to bring that to a level of a consciousness, and the American consumers are starting to say, hang on, wait a minute, this is data about us that's going out to everybody on the planet because of these breaches. Where are our rights being protected because of this? So I think we're starting to move towards Europe in our attitudes toward privacy.
Jonathan, looking at the statistics of the Information Commissioner's helpline, over the past 3 years or so, it seems that the number of calls to your helpline, to the bat phone, has doubled in 3 years. So this is the consumer pressing you guys for help, but for action as well. I mean, are you seeing this idea that the consumer, as the consumer who is engaged in regulation and supervision, being a real thing in this territory now?
I don't think it's as prominent as you might imagine. I mean, we do get a lot of people come to our helpline. Even more people come to our website to find out things as well.
Yeah.
But, I can't say that it necessarily reflects the level of concern that people have, generally. Often it just manifests itself because those people have had a particular problem or have a particular concern. One of the things that I think is encouraging the way the sort of jurisprudence has gone, it's almost more to a democratisation of people being able to enforce their own privacy rights. A few years ago it was only the likes of Naomi Campbell and others who would take cases related to privacy. Now you're actually finding it's individuals who are not quite so well resourced. You're actually finding there's activist armies. Many of the cases you mentioned are through pressure groups and activists. And I think the changes that we see and potentially the result of cases has been where you can claim compensation where you just suffer distress, not damage, that will get some more and more cases coming forward. Bridget rightly says security breach notification, if that's mandatory and happens and everybody's told about it, then, if I'm slightly cynical when it comes to these things, I'll be seeing adverts on the telly from firms of lawyers saying, has there been a security breach involving you? Ring this number now and we'll take the action.
Yeah, it's happening already.
Yeah.
So that takes in nicely into our final theme before you all give me a single pearl of wisdom or two. This breach notification bit, so we've been skirting around it. Jonathan, you've reintroduced it. But so, Bridget, I'll ask you, if you just give me 60 seconds about where Europe is in terms of mandatory breach disclosure. So what's going to happen if the regulation's adopted? Would you mind telling the guys?
Sure. So if the regulation is adopted, there will be some kind of mandatory breach notification. It's not clear what the threshold will be. And it's not clear whether organisations will need to notify both the regulator and individuals. So those elements are still up for negotiation. It's also interesting that in the council proposal, there is some real focus actually on the harm that might be caused to individuals and an opportunity for companies to put the breach right and address that harm and then make a decision as to whether or not they need to notify, which I think is interesting. So we have a lot of uncertainty around the detail, but I think there's a lot of consensus around the need for breach reporting.
So Richard, very quick question to you, quick answer please. Breach notification, has that changed the dynamic of security and privacy in the United States? Is that at the heart of this changing attitude?
Yes.
Jonathan, that's fantastic. It's clear as that. There we go. Brilliant. It's going to change it all. Jonathan, the Information Commissioner has been a fan of breach disclosure for a number of years. But where's this really going? Is this about helping us to understand the causes of failure? Is it about helping us to mitigate harm? Or is breach disclosure really about helping the regulators get evidence so they can give entities a good old spanking?
Well, I should follow Richard and say yes. But,
They're not on that one.
I mean, it's a bit more complicated than that, because we're only a fan to the extent. It goes to what Bridget said, actually. We think this is context-driven, and, you know, there's a risk level that must drive the breach notification. The unthinking, some internal breakdown of security procedures which doesn't have any effect on the outside world, that shouldn't be subject to mandatory breach notification. But where we do have ones which come forward, yes, if I think about my virtuous circle of regulation, I need organisations to be incentivised to do the right thing in the first place. If some element of exposure of their failures help them do that, then that's something that should be in that mix there. What I don't want is a public who get notification fatigue because they're being told about so many inconsequential breaches that they don't pay attention to the ones that really matter, and importantly don't take the action in the cases that really matter.
So Steve, very quick answer, so quick question to you, quick as you can please. Are execs worried about this breach notification piece?
Yes.
Great, fantastic. Really worried. Lovely. Okay, so guys, we're going to wrap this up. We're going to bring this home. So we're building for you probably the best and smartest strategy, so I hope you've been taking notes, for dealing with this increasing global regulatory oversight. You know, this is literally worth hundreds of thousands of pounds worth of advice. So we'll be passing the hat round in a minute. But before we get to that final bit, I'm going to ask the guys just for their top tip. They've all been thinking about it. So being smart in this global environment, for their top tip. So who wants to take the first one? Bridget, you're looking at me with eagerness. It's your go. Top
Am I
tip.
limited to one? Can I have
You
two?
can have, well, you can have one because you
And you
might
come
get
back.
there second.
Okay,
You can have, let's see if it's not the same. Do your first and then we'll come back to you.
Okay, so my top tip sounds really simple, and it's know your data assets. And that means that you really need to have a good idea of what information your organization is collecting through all its different sort of sources, how it's processing that information, where it's processing that information, who is processing the information, how much of it is personal data and regulated. But if you don't know that information and you don't really have some detail on it, it's going to be impossible to comply with the data protection framework or to plan ahead and enable your business to do more with the data.
Fantastic. That'll be £10,000, please, on the way out. Richard, top tip.
Engage your regulators early, often, and develop a relationship with them.
You've just stolen his one now. Steve, how about you? What's your one? Let Jonathan think another one up.
Mine's quite straightforward. Okay, there's some golden rules that we've adopted in Unilever, and we call it the 5 W's. It's fantastic, right? It's so simple, right? It is literally know where your data is, know why you have that data, know who has access to that data, know what the data is trying to do or what you're trying to do with the data, and know when you want to get rid of the data or how long you need to retain the data for. If you apply those 5 W's to your systems, your processes, your organization, you will be
sorted in a strategic sense.
exactly.
So, where you need to be, or on the World Wide Web,
yes.
or anything else beginning with W. Jonathan, what's your one?
Okay, well, as a number of mine have already gone, I'll say, I would just say to you, think about risk, not just your own neck risk in terms of the organisation. Think about risk in terms of the vulnerabilities of information and how that has an effect on individuals. Because when we come to look at it as regulators, we're often looking at what's the effect on those individuals of this. And it's easy not to think that one through properly. But that's the first thing we think about, is what's the impact on individuals there. And that should drive your policies forward.
You can have your fifth, but it's got to be 10 words. Or 5
I
W's.
can't count that high. So this whole set of issues is about a lot more than just security. Security is incredibly important, obviously, but actually these regulations go much beyond security. Security is one part of the overall risk framework. And you've got to look at some of the other issues as well, including, whether you've actually got a legal right to use the data for all the wonderful things that your creative teams are thinking about.